Welcome to Business Connection. I'm Liz Spencer. We have a great guest in studio today. It's Mark C. Metzger, attorney at law from the law offices of Mark C. Metzger. Welcome.
Thank you, Liz.
Now, you specialize in wills and trusts and all those things that we don't want to talk about.
Well, yeah, I guess that's true, although I should say this. The Illinois Supreme Court really doesn't let us claim specialization in anything. My practice does concentrate in wills, trusts, and estates, and also some real estate matters. But we help people with estate planning at all levels, up to and including Medicaid spend-down avoidance for family members that are headed to the nursing home and trying to protect their assets.
True. So, well, let's start basic, because this is something that we don't like to talk about.
A lot of people don't.
So let's talk a little bit about a difference between a will and a trust.
Sure. Well, a will is a document that has existed for centuries. It is the definitive place to say three things. What do you want done with your stuff when you're dead? What guardian do you want to appoint for your minor children? And what do you want done with your physical remains? Burial versus cremation, for example. So that's the definitive tool to decide what the answers to those three questions are. These days, a lot of people are also using a trust in combination with that will to help solve some other problems. So a trust, I think probably the simplest way to think of a trust is it's just a bucket. But instead of a bucket that holds water or paint or sand, it's a bucket that holds assets. This makes it easier for them to manage, easier for them to carry around. So all the same reasons you would use a bucket for sand, you could use a bucket to hold your assets as well. It's a more efficient tool for managing them.
I think we all think we need trusts if we have a lot more money.
I think that from a default perspective, that was very common for a number of years. The thinking was that trusts were for wealthy people, and for a long time they were, because the principal reason people used them was to avoid estate taxes. These days you can use the trust as a tool to solve all kinds of other problems other than just estate tax avoidance. For example, avoiding probate is the most common reason that people in the Naperville area would use a trust, for example.
Now, we hear that word probate a lot, but what does that really mean? What is probate?
Probate is a process that's probably 200 plus years old at this point. It was a process that was invented to make sure that creditors get paid when somebody passes away. The thinking was that just because somebody died, their debts shouldn't go unpaid. And so it's a process that involves the courts. It essentially means that if your estate is of a sufficient size, your executor is required to tender a list of the assets and the heirs and the relatives in the family to the court, share that information with the court. Back when people used to read the newspaper, the first part of the want ads was always the legal notices. If you ever read any of them, most of them were probate notices, and they said, notice is hereby given that on January 15, 2015, John Smith passed away, and here's the name of his executor, here's the court number for his probate file, here's the lawyer's name and the judge's name. If you have a claim, make it, and that starts a 6-month clock. So for 6 months, the judge is going to hold his or her arms around all those assets and supervise the distribution of those and the processing of any claims that are made against the estate. And a minimum of 6 months later, if everything has been processed accordingly, the estate will finally be released to the executor to be distributed to the family or whoever it is that's supposed to receive it.
And so do you go into probate if you don't have a will or a trust, or can you still go into probate with a will and a trust?
Well, you can go to probate no matter what.
No matter what.
Yeah,
okay.
the question of how you go to probate really is a matter of what the size of your probatable estate is. If it's over $100,000, you're going to probate. Okay. So as strange as it sounds, if you make a trust, you make one of these buckets, and you decide what assets you're putting in the bucket, and you decide what assets are coming out and when and to whom and so forth. And most people have heard this phrase, revocable living trust. That's a trust where you made the trust, you're the trustee of the trust, you are your own beneficiary. You can do whatever you want with that trust during your lifetime for the most part. Even though you've done that, the law says if you put assets into your bucket, they don't count toward that $100,000 to determine whether or not you're headed to probate. So people will use a trust as a tool to avoid probate because it avoids that delay. Frankly, anything in the law that is delayed and slow is very expensive.
Right.
This is an effective tool to avoid that, which means families can end up saving a lot of money and process their estates much more quickly.
Right, and another valuable tool that you help people with is that power of attorney. And we are all have aging populations, and we often get involved with will and trust as adult children, and then need to have certain legal rights with our parents, that we just lots of people just assume, well, Dad said it was all right, but the law doesn't recognize that.
The law doesn't recognize what Dad said, only what Dad wrote.
Right, yeah, even though we do, Dad's the law,
the power of attorney, and there's two of them that most people need to think about: a power of attorney for healthcare and a power of attorney for property. When lawyers say property, we don't mean just real property, but all property. All your personal possessions, your cash, everything is property. A power of attorney for healthcare, a power of attorney for property is a tool that lets you appoint someone to speak for you or handle your affairs for you if you cannot. They don't survive our death, but while we're incapacitated or unconscious, this would allow someone to manage our financial affairs or manage healthcare decision making. Several years ago, I gave my parents powers of attorney to sign, and my dad commented at the time, sort of half joking, do you really think we're in that bad a shape that we need to do this now? And I pointed out to him that by the time I actually needed the power of attorney, it would be too late to get it because I wouldn't be competent.
Right. Well, and there are other, we think about aging attorneys, but, husbands and wives and other people have power of attorney so that they can be there and be that legal voice if something should happen.
Exactly right. And a power of attorney for property is a useful tool for a married couple in every instance, regardless of age, because, these days with privacy and financial privacy and medical privacy, there's all sorts of roadblocks that get put up if you try to talk on the phone about your partner's, medical need or insurance issue or whatever. They're automatically going to get in your way. A power of attorney lets the other spouse deal with some of those issues as well, which makes just those processes more convenient. So I think a proper estate plan at a minimum has a will and a power of attorney for property and a power of attorney for health care associated with it to kind of solve that whole group of problems. The power of attorney for health care, too, I think is something that people get confused about.
Right.
In the late 70s, we all got inundated with the Karen Ann Quinlan story. And this battle between her parents and her husband over who was going to make the decision about whether she was going to be unplugged from the life support machine. And the General Assemblies all throughout the country rallied into motion, and they all passed these statutes saying, we're going to have living wills, and people will be able to express their needs, and then we won't have these problems anymore because we'll know what the patient wanted. And that worked fine until the 90s when people started going to the hospital and they were put on a life support machine, and one of the children would come in with a power of attorney, or a living will, and it'd say to the hospital administrator or the doctor, Mom doesn't want to be kept alive artificially. And so they'd go to turn it off, and the other child would say, no, I talked to her last night, she changed her mind. And so we discovered there was a new problem, and the new power of attorney for health care attempts to solve that problem by actually giving someone the legal authority to make that decision. So there's no more debate about what Mom last told somebody. This person has the authority to make a decision, and that's what
and it's only one family member who can have that.
Exactly.
Well, and not only, we often think about it in an elderly parent situation, but it's nice to have for, if you are a single person and have siblings or something like that. It may
be even more important for single people. In fact, a friend of mine who does what I do on the East Coast in Cambridge, Massachusetts, has been reaching out to families of students enrolling at MIT and Harvard and saying, you're an adult now,
right?
But there's nobody else in your life to make some of these decisions for you. Maybe you need to look at this package of powers of attorney and get your life organized in a way that most people have never thought of at that age.
Well, the type of law or the needs that we would come to you for are very important, whether it be wills, trust, power of attorney, or even, planning for, selling our home and moving into an assisted living campus or something like that. All things we don't want to face.
No, I think people are intimidated by a lot of that. Some of it is that it's facing your own demise, and some of it is facing some uncertain realities about what the future brings, and all of that is uncomfortable. As much pre-planning as you can do, though, I think makes things much easier for the family. They know, well, this is what Mom wanted, this is what Dad wanted, and they've managed to express that, and in many ways avoided lots of discomfort and angst that the family would otherwise go through later. I think that's particularly true in the Medicaid context, where people are headed to the nursing home and they're worried about, frankly, running out of money. Because at the tune of $8,000 a month, that happens pretty fast.
It's like sending Mom and Dad to graduate school.
Yeah, exactly.
It is. And you're already emotional enough during that time period. It's nice if the family has planned ahead for the will, the trust, and the POA and all of that. Mark, thanks for stopping by and sharing a little bit with us and helping nudge us in the right direction of getting our plan together.
Thanks very much.
It was nice to meet you.
You too.
We'll be right back with more Business Connections. Stay tuned.